Welcome to Breaches Are for Whales. Come build your DPIA muscle memory. Data privacy and security assessment using the MITRE attack and OWASP tools. If you would like to learn more or would like to attend a workshop if it were to become available, please contact us at Privacy Test Driver. Valdez Ladd, Mauricio Tavares, Kim Green. Archimedes famously said, "If you give me a lever and a place to stand, I can move the world." If you understand the forces and have a solid grounding, you can shift anything. You can shift your data world into privacy. The tragedy of best practices after a breach is that we have identified the most common risks, but we are not putting forth the effort to eliminate or mitigate them. There are breaches that could have been stopped, that should have been stopped. Costs are not limited to legal defense, compensation payments, bad publicity, and loss of trust. Why use a Data Privacy Impact Assessment, or DPIA? A DPIA is a process to help you identify and minimize the data protection risks of a project. A DPIA will improve your data privacy awareness, documentation of processes, and can reference common methodology for cross-silo communication and cooperation. You need to know your customer, whether it's a public consumer or you are business to business. You need to make informed decisions about data privacy and data compromise risk. Business trust involves knowing business risk. Current security focus creates data privacy limitations. Internal inefficiencies undermine security analytics and operations, and trusted employee access carries both risks of misconfiguration and deliberate insider compromise. Current incident response resembles more break glass in case of emergency. If you conduct a DPIA, you will know where your data is, where it is used, and will enable you to lead with data privacy policies and procedures of your crafting. DPIA promotes best practices for data security and data privacy incident management. The pandemic-led recession means that companies facing lost revenues will scrutinize their supply chains and reduce suppliers. Companies that are both data security and data privacy-centric will beat their competition and survive the recession. The right to privacy is that one's personal information is protected from public scrutiny. U.S. Justice Louis Brandeis called it the right to be left alone. While not explicitly stated in the U.S. Constitution, some amendments provide some protections. The right to privacy is most often protected by statutory law. For example, the Health Information Portability and Accountability Act, or HIPAA, protects a person's health information. The Federal Trade Commission, or FTC, administers a wide variety of laws and regulations, including the Federal Trade Commission Act, Telemarketing Sale Act, Identity Theft Act, Fair Credit Reporting Act, and Clayton Act. A person has the right to determine what sort of information about them is collected and how that information is used. Data protection is the term used in the EU, whereas in the US it is referred to as information privacy. Importantly, data protection is very different from data security in that it extends beyond securing information to devising and implementing policies for its fair use, including data processing. A common current definition of personally identifiable information, or PII, personal data means any information relating to an identifiable natural person. An identifiable natural person is one who can be identified directly or indirectly by reference to an identifier, such as a name, identification number, location data, online name, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. Personal data is the term used in the EU, whereas in the US it is referred to as personally identifiable information. For developers, an important note is that this also includes IP addresses, mobile device IDs, browser fingerprints, RFID tags, MAC addresses, cookies, telemetry, user account IDs, any other form of system-generated data which identifies or could identify a natural person. Confidentiality, integrity, availability. These principles form the cornerstone of any organization's structural security. Anytime data is leaked, a system is hijacked, a user takes phishing bait, a website is maliciously taken down, or any number of other security incidents occur, one or more of these principles has been violated. Confidentiality is ensuring that only those who are authorized have access to specific assets, and that those who are unauthorized are actively prevented from obtaining access. For example, only authorized payroll employees should have access to the employee payroll database. Integrity is ensuring that data has not been tampered with and therefore can be trusted. Ensuring integrity involves protecting data in use, in transit, such as sending an email, uploading or downloading a file, and when it is stored, whether on a laptop, portable storage device, in the data center, or in the cloud. E-commerce customers expect product and pricing information to be accurate, and that quantity, pricing, availability, and other information will not be altered after they place their order. Banking customers need to be able to trust that their banking information and account balances have not been tampered with. Availability is ensuring that authorized users have timely, reliable access to resources when they are needed. Networks, systems, and applications all must be up and running. Many things can jeopardize availability, including hardware or software failure, power failure, natural disaster, human error, or denial of service attack. The Parkerian hexad replaced the CIA triad, as the triad is inadequate for cloud computing complexity and exponential growth. The larger scope of the hexad encompasses both cloud computing and distributed computing. Confidentiality is defined as the quality or state of being private or secret, known only to a limited few. Proprietary and personal identifiable information may in fact be confidential or not confidential, depending upon the nature of the information or timing of the information release. Authenticity is defined as authoritative, valid, true, real, genuine, worthy of acceptance or belief by reason of conformity to fact and reality. Integrity is defined as unimpaired or unmarred condition, soundness, entire correspondence with an original condition, the quality or state of being complete or undivided, wholeness. Authenticity is not part of integrity and has a different property, the validity or genuineness of the information. Non-repudiation would fit in here. Utility is defined as usefulness, fitness for some purpose. Information, even if available, must be usable, having utility. Availability is defined as capable for use for the accomplishment of a purpose, immediately usable, accessible, and may be obtained. Possession or control is defined as a state of having in or taking into one's control or holding at one's disposal. Actual physical control of the property by one who holds themselves, as distinguished from custody, something owned or controlled. The hexad considers possession as an important element which may impact confidentiality. The possession of confidential information can sometimes lead to threats such as blackmail, extortion, sabotage, or destruction. Example of lost possession is ransomware. Organizations targeted by this type of attack have sensitive data, high data availability requirements, low tolerance for system downtime, and the resources to pay a ransom. Prior to initiating attack, a malicious actor usually gains unauthorized access to the victim's information, and is deployed to produce maximum effort. This is a hard call. If you do not have backup rotation and periodic restores to test your system, you may not have safe backups to restore from. The FBI recommends not paying ransom because there's no guarantee you get your data back, and because you are now on a good eats list and are likely to be hit by several waves of ransomware, as your name is sold and multiple bad actors try to cash in on your situation. Unfortunately, if you do not pay ransom, you may also have some information leaked, or be publicly put on the wall of shame. A breach is defined as the acquisition, access, use, or disclosure of protected health information in a manner not permitted by HIPAA rules. HIPAA breaches include unauthorized access by employees as well as third parties, improper disclosures, exposure of protected health information, and ransomware attacks. The U.S. Department of Health and Human Services, Office for Civil Rights, or OCR, investigates data breaches that impact more than 500 individuals to determine whether HIPAA violations have occurred. When HIPAA rules violations are discovered, financial penalties may be deemed appropriate. Privacy by design means that privacy is proactive and embedded. Reactive leads to higher cost. Stop the privacy bleeding. Stop the financial and reputation losses. Default to privacy as an integral part of a service or product. Fail safe. Fail shut. There's a data life cycle, from development to operations, and must be deleted at the end of the product or service. So there is a data expiration date. And think privacy. Think customer. Be ethical. There is currently no mandated method of performing a DPIA. This is one recommended method. You will need to improve and involve security in all stages of your operational lifecycle and production lifecycle with the blessings of management buy-in. For the operational lifecycle, keep in mind that PII and your business case for gathering and using PII. The typical continuous integration and delivery system requires continual privacy and security monitoring, maintenance, and defense. You may need a version control repository for storing text files, source code, infrastructure templates, and server configuration. Continuous integration for testing and validation. User tests, or UAT, user acceptance test. They give the user an eyeballs and may discover more issues which you do not notice from a different point of view. DevOps tests simulate production, and security tests for libraries, source code, and runtime. Continuous delivery involves incremental updates to production once it passes, part of the Agile concept. Right now, production includes security on top of operations. But when operations and privacy are done together as a coordinated team, you can reach full production speed. Coordinate the security team, the operations team, and the privacy team. Embed security and privacy for greater reliability and efficiency. In the production lifecycle, you need to know your customers, users, and partners. Protect from bad data, fraud, and attackers. So at the edge, you'll have a web page inputting validation testing. Firewall could prevent further attacks and separate resources. Zero Trust is a best practice. Partner this with network segmentation. Load distribution is essential to microservices and distributed applications across a server farm. AWS Elastic Load Balancing has options for SSL and TLS decryption. We're encouraging confirming available security features and enabling them. Most features are optional and not on by default. Observability, logging, metrics, tracing, distributed tracing. The web server serves up web pages and interactive content, which calls to the application server to perform business logic, to complete the user's queries and requests, which pulls from the database, which holds business and application records. Data, including PII, should use encryption and hashing. Know how your software manages data and how to defend your work and your company if you process PII. Consent must be freely given. This means giving people deliberate, ongoing choices and control over how you use their data. Genuine consent should put individuals in control, build trust and engagement, and enhance your reputation. Relying on inappropriate or invalid consent could destroy trust and harm your reputation and may leave you open to large fines. Contractual necessity delivers contractual service to them, or because they have asked you to do something before entering into a contract, such as providing a quote or work estimate. Legal obligations required by law and regulation. All data privacy laws have these things in common: data protection, data processing, fair use, data subject access request, and breach notification requirements. Vital interest. This lawful basis is very limited in scope and applies to matters of life and death. It applies to emergency medical care when you need to process personal information for medical purposes, but the individual is incapable of giving consent. It is not appropriate for medical care that is planned in advance. The lawful basis of public task or legitimate interest is more appropriate for that. Processing of one's individual personal data to protect the vital interests of others is rare, such as processing a patient's and parents' personal data to protect the vital interests of a child. Vital interests also apply for processing humanitarian grounds, such as monitoring epidemics, natural or man-made disaster, such as COVID tracking, and contact tracing. Public interest or task. In the exercise of official authority, carrying out a specific task in the public interest which is laid down by law, or exercising official authority laid down by law. Legitimate interests. This is not part of normal duties. They can be your own interests or interests of third parties, and commercial interests as well as wider societal benefits. They may be compelling or trivial, but trivial interests are most easily overridden by individual privacy concerns. The GDPR specifically mentions use of client or employee data, marketing, fraud prevention, intragroup transfers, or IT security as potential legitimate interests. It also says that you have a legitimate interest in disclosing information about possible criminal acts or security threats to the authorities. Always bear in mind the lawfulness, fairness, and transparency. Processing must be lawful, fair, and transparent to the data subject. The purpose limitation. You specifically process data for a purposely selected occurrence. Data minimization. Collect and process only as much as you absolutely need. Accuracy. Keep it accurate and up to date. Storage limitation. Only store PII for as long as necessary for the required purpose. Integrity and confidentiality. Processing must be done in such a way as to ensure appropriate security, integrity, and confidentiality, such as by using encryption. And accountability. The data controller is responsible for being able to demonstrate GDPR compliance with all these principles. This is not new. The first data protection law in the world was enacted by the Swedish Parliament in 1973. The intention of the law was to protect personal privacy and regulate misuse of personal information databases. Back then, the main concern was the relationship between government and citizens, rather than the relationship between private sector and citizens, probably because at the time only a handful of companies possessed computers. But that law, however, defined personally identifiable information in a very wide way. Every single occurrence of any kind of data pertaining to an individual was, according to this law, personal information. Even if the name of the person was not mentioned, this was still covered under law. You had to have permission in advance. Original legislators already had some inkling of the conflict between this law and freedom of speech because they specified that photo typesetting systems used by newspapers were exempt. This was probably the only kind of pretext processing that legislators at this time could envision. The Health Insurance Portability and Accountability Act of 1996, HIPAA, regulates protecting the privacy and security of certain health information. The HIPAA Privacy Rule and the HIPAA Security Rule. The Privacy Rule, or Standards for Privacy of Identifiable Individual Health Information, establishes national standards for the protection of health information. The Security Rule, or Security Standards for the Protection of Electronic Protected Health Information, establishes a national set of security standards for protecting health information that is held or transferred in electronic form. Electronic Protected Health Information, or EPHI. Prior to HIPAA, there was no generally accepted set of security standards or requirements for protecting health information in the healthcare industry. Today, providers using clinical applications such as computerized physician order entry, CPOE systems, electronic health information, or EHR systems, radiology, pharmacy, laboratory systems. In addition, health plans are providing access to claims in healthcare management, as well as member self-service applications. The PCI Security Standard Council's mission to enhance global payment account data security by developing standards and supporting services that drive education, awareness, and effective implementation by stakeholders, 2004. PCI certification has 6 objectives, verified by a series of test and compliance procedures, confirmed by an entity authorized to carry out certification. To build and maintain network and system security, to protect cardholder data, to maintain a vulnerability management program, to implement strict access control measures, to monitor and test networks regularly, and to monitor and maintain an information security policy. The right to privacy is part of the 1950 European Convention on Human Rights, which states, everyone has the right to respect for his private and family life, his home, and his correspondence. From this basis, the European Union has sought to ensure the protection through legislation. In 1995, the EU passed the European Data Protection Directive, establishing minimum data privacy and security standards. To put this into context, in 1994, the first banner ad appeared online. In 2000, a majority of financial institutions offered online banking. In 2006, Facebook opened to the public. 2011, Google sued the company for scanning their email. 2 months after that, Europe's Data Protection Authority declared that the EU needed a comprehensive approach on personal data protection, and work began to update the 95 Data Protection Directive. GDPR entered into force in 2016, and as of May 25, 2018, all organizations are required to be compliant. First, if you process the personal data of EU citizens or residents, or you offer goods and services to such people, GDPR applies to you even if you are not in the EU. Secondly, fines for violating GDPR are very high. There are 2 tiers for penalties, plus data subjects have the right to seek compensation for damages. export of personal information can be allowed outside the EU if the target country provides adequate privacy protection. And, as an important note, publicly available web pages are exported outside Europe since anyone on the internet can access them. The California Consumer Privacy Act of 2018, CCPA, gives consumers more control over the personal information that businesses collect about them. The right to know about personal information a business collects about them and how it is used and shared. The right to delete personal information collected from them, with some exceptions. The right to opt out of the sale of their personal information. And the right to non-discrimination for exercising their CCPA rights and not allowing use of their personal information. CCPA applies to any business which does business in California, including data brokers, that satisfies at least one threshold: annual gross revenue in excess of $25 million, buy, receive, or sell information of 50,000 or more consumers or households, or earn more than half of annual revenue from selling consumer personal information. Some key differences between CCPA and the EU's GDPR include the scope and territorial reach, definitions related to protected information, levels of specificity, and the opt-out right for sales of personal information in CCPA versus the opt-in necessity for GDPR. And importantly, CCPA only considers data that was provided by a consumer and excludes personal data that was purchased by or acquired through third parties. The GDPR does not make that distinction and covers all personal data regardless of source. The United Kingdom Data Protection Act, DPIA, 2018, controls how personal information is used by organizations, businesses, or the government. Everyone responsible for using personal data has to follow strict rules called data protection principles. They must make sure the information is used fairly, lawfully, and transparently. Used for specified explicit purposes. Used in a way that is adequate, relevant, and limited only to what is necessary. Accurate, and where necessary, kept up to date. Kept no longer than is necessary. Handled in a way that ensures appropriate security, including protection against unlawful or unauthorized processing, access, loss, destruction, or damage. There is also stronger legal protection for more sensitive information, such as there are separate safeguards for personal data relating to criminal convictions and offenses. GDPR requires those processing criminal data to have official authority. DPA does not. Your rights. Under the Data Protection Act of 2018, you have the right to find out what information the government and other organizations store about you. These include the right to be informed about how your data is being used, access personal data, have incorrect data updated, have data erased, stop or restrict the processing of your data, data portability, such as allowing you to get and reuse your data for different services, object to how your data is processed in certain circumstances. You also have the right, when an organization is using your personal data for automated decision-making processes without human involvement, and for profiling, for example, to predict your behavior or interests. GDPR states that data subjects have the right not to be subject to automated decision-making or profiling, whereas DPA allows for this whenever there are legitimate grounds for doing so, and safeguards are in place to protect individual rights and freedoms. Why do these differences matter? Because in an EU member state, data can flow unhindered across borders, making business cheaper, faster, and easier. The UK left the EU. Data will no longer be able to rely on data flowing freely, and this now depends on data protection laws being considered adequate. Since Brexit happened on January 31st, 2020, a new and amended Data Protection Act has taken effect. Under DPIA, there is stronger legal protection for more sensitive information such as race, ethnic background, political opinion, religious belief, trade union membership, genetics, biometrics, health, sex life, or orientation. GDPR gives member states limited scope to shape how their regulations apply in their country. The differences can include the age of child consent. GDPR states that a child can consent to data processing at 16, while DPIA sets this at 13. There's an extended definition of identifier. GDPR extends the meaning of identifier to include IP addresses and internet cookies, and data which tracks a visitor's movement to a website, and DNA and definition of personal data. Standards on which are based best practices. This starts with ISO 27001 in 2013. Add bits and pieces from ISO 27018 of 2019 as you progress in your implementation project. Security controls in ISO 27002 and 27001 are pretty much the same, only 27002 explains them in greater detail. ISO 27001 2013 is the international security standard that provides a framework for information security management systems, ISMS, to provide continued confidentiality, integrity, and availability of information as well as legal compliance. Certification is essential for protecting your vital assets like employee and client information, brand image, and private information. The ISO standard includes a process-based approach to initiating, implementing, operating, and maintaining your ISMS. It covers physical, technical, and regulatory controls and ensures that security arrangements are fine-tuned to keep pace with changes to security threats, vulnerabilities, and business impacts. Ongoing risk assessments help to identify security threats and vulnerabilities that need to be managed through controls. ISO 27018 of 2019 is the Code of Practice for Protection of Personally Identifiable Information (PII) in public clouds, acting as PII processors, focusing on protecting personal data in the cloud. This ISO works in two ways. It augments the existing ISO 27002 controls with specific items for cloud privacy, and it provides several completely new controls for personal data. It has the following objectives: to help the public cloud service provider comply with applicable obligations when acting as a PII processor, whether such obligations fall on PII directly or through contract. To enable the public cloud PII processor to be transparent in relevant matters so that cloud service customers can select well-governed cloud-based PII processing services. To assist the cloud service provider and the public cloud PII processor entering into contractual agreement, and provide cloud service customers with a mechanism for exercising audit and compliance rights and responsibilities in cases where individual cloud service customer audits can be impractical technically and can increase risks to physical and logical network security controls. This document is applicable to all types and sizes of organizations, including public and private, government entities, and nonprofits, which provide information processing services as PII processors via cloud computing under contract to other organizations. ISO 27701 2019 is a data processing extension to ISO 27001, providing guidance for establishing, implementing, maintaining, and continually improving a Privacy Information Management System, or PIMS. This reduces risk to privacy rights of individuals and to the organization by enhancing existing ISMS. It was created to support compliance with GDPR and other privacy requirements. There is significant overlap between ISMS and PIMS, so it encourages you to implement both ISO 27001 and ISO 27701. Currently, there is no one-size-fits-all tool for data privacy and security. It is unreasonable to expect complete protection from a single tool because some risks are triggered by vulnerabilities that are not yet known, and other risk groups are not yet formally mapped to vulnerability classes. The OWASP Top 10 Web Application Security Risks is to build awareness of the most common exploits that hackers use to infiltrate and compromise data within web-based applications. As you can see, the risks have significant overlaps. It has become an unofficial industry standard that guides and directs the security approach of many companies today. The OWASP Top 10 Privacy Risks Project lists privacy risks in web applications and related countermeasures. It covers technical and organizational aspects that focus on real-life risks, not just legal issues. The project provides tips on how to implement privacy by design in web applications, with the aim of helping developers and web app providers to better understand and improve privacy. AWS Security Hub collects security data from across AWS accounts and services and supported third-party partner products. Security Hub processes finding data using a standard finding format. Security Hub correlates findings across providers to prioritize important ones. And Security Hub runs continuous configuration security checks, resulting in readiness score. It identifies specific accounts and resources that require your attention. You can also create insights in Security Hub. An insight is a collection of findings that are grouped together when you apply a group by filter. Insights help you identify common security issues that may require remediation. Security Hub includes several managed insights, or you can create your own custom insights. This allows you to view your overall current security status to spot trends, identify potential issues, and take the necessary remediation steps. MITRE ATT&CK TTP is useful for a privacy director and engineer to communicate with their security team in a common structured language. ATT&CK stands for Adversarial Tactics, Techniques, and Common Knowledge. Tactics, techniques, and procedures are how threat agents, the bad guys, orchestrate and manage attacks. TTPs are the patterns of activities or methods associated with a specific threat actor or group of threat actors. Indicator of compromise subsets are then scanned and investigated. This framework is a matrix of intrusion techniques sorted into 11 different tactics. Initial access. Techniques that use various entry vectors to gain their initial foothold within a network. Techniques used to gain a foothold include targeted spear phishing and exploiting weaknesses on public-facing web servers. Execution. Techniques that result in execution of attacker-controlled code on local or remote system. Persistence. Any attack, access, or action or change to a system that provides an attacker with a persistent presence. Privilege escalation. Techniques that provide an attacker with higher permissions on a system or network. Defense evasion. Techniques that an attacker may use for the purpose of evading detection or avoiding other defenses. Credential access. Techniques resulting in the access of or control over system or domain or service credentials. Discovery. Techniques that allow an attacker to gain knowledge about a system and its internal network. Lateral movement. Techniques that enable an attacker to access and control remote systems on a network. Collection. Techniques used to identify and gather information from a target prior to exfiltration. Exfiltration. Techniques that result or aid an attacker removing files and information from a target network. Command and control. Techniques that allow attackers to communicate with controlling systems within a target network. Impact. The adversary trying to manipulate, interrupt, or destroy your systems and data. Even if they don't exfiltrate data, they can still throw a monkey wrench into your processes and impact systems and data. When, not if, there's a privacy compromise, which may or may not be from an advanced persistent threat, you need to identify the breach with security alerts, logs, AWS Security Hub. You need to assess the breach impact with privacy loss, what legal repercussions are there, and general doom. After a breach or compromise, you should have a post-mortem. What did we do right? What should we have done that we did not do? Or that we did incorrectly or incompletely? Revise and review your DPIA based on MITRE ATT&CK and OWASP Top 10 Privacy Risks analysis of the compromise you just had. Prioritize where to put your effort. Cat herd upper management for support to make effective change and prevent a recurrence. Joseph Schumter, an Austrian economist, found in his research, nothing is so treacherous as the obvious. You cannot assume data privacy is obvious. You have to make it so. When you think security, think privacy. Thank you. There are some useful links in the following slides.